Thank you, Senator. Senator Carr.
Thank you, Mr Acting Deputy President. Look, if we ever needed any evidence of this government's chaotic state of affairs, if we needed any evidence of a government that seems to be lurching from one half-baked proposal to another, then I think the evidence is before us with this particular bill. Now, it's less than 3 months ago this chamber had the opportunity to consider the Building and Construction Industry Bill, and the Prime Minister came away from that. He crowed about the passage of the legislation restoring the ABCC Commission. Now, he said this was a vital economic reform. And of course now this government wants to scrap its own reform. Now, the Labor Party said that the ABCC bill was wrong, principle. We said that it was actually going to lead to a reduction in productivity and it was going to lead to an increase in the work sites in this country being much, much more dangerous places. The law passed, of course, with the support of the crossbenchers, many of those crossbenchers, including Senator Hinch, Hanson and Xenophon. In fact, they were so proud of much of the Minute Bill, they helped the government push through the parliament. But it seems that they've had a change of heart as well. Indeed, the specific provisions that are amended by the present bill were proposed for the earlier bill by Senator Hinch and accepted by the government. Now, it's reported that Senator Hinch, and I think he confirmed it today, that he had a lunch with the Prime Minister during the summer break. It's quite clear that it's the Australian working people that have been left to pick up the tab for that lunch. And what we know here is this is a continuation on the war against building workers, which has been initiated by this government, prosecuted by this government for many, many years. We know that one of the great fundamental divides in politics around the question of who gets what, when and why is in the issue of industrial relations. And the fundamental question arises because of the working people wanting to actually regulate their working environment so as to improve their capacity to enhance their living standards, enhance their conditions at work. And of course Conservatives who have argued about the deregulation of the working environment to allow employers the maximum flexibility and maximum capacity to improve their profit position. Now, this fundamental divide, as I say, has been really the issue that has been characterised Australian politics pretty much for the last 120 years. The great moments in history have often been around the question of the capacity of unions and working people to actually defend themselves. The great strikes of the 1890s, which of course were such a catalyst for the formation of the Labor Party because of the perception that developed widely in this country that industrially workers could only secure so much and because they could always rely upon conservative forces using the state to try to bash them into submission. The capacity of the state to undertake anti-union, or in fact union-busting activity, of course, has been a hallmark of conservative politics throughout this period. And we've seen that through various stages, and I won't go through each and every one of them. But the principle remains the same today. Fundamental principle of the Liberal Party is its commitment to union-busting activity. Now, it's not just the smashing of organised labour, it's the smashing of workers' capacity to defend themselves. And why is it that the union that's directly in line now is the CFMEU? It's because it's one of the strongest and most effective unions in Australia today. And it's not just the smashing of the CFMEU that's at stake here, because the issue actually affects all workers and their capacity to organise. And breaking the CFMEU, of course, is fundamental to the capacity to break all unions in this country. I'm particularly concerned about Senator Hinch's role in this. Senator Hinch, in the last election, made commitments because around in industrial relations. He made commitments to the Victorian branch of the Labor Party upon which he received a preference arrangement from us. And Senator Hinch, I defy you to deny that. Those commitments have now been broken. Categorically, you have broken your word in regard to the approach that you would take on industrial relations, a matter of such importance to us that we made it a condition of providing support in terms of the preferences in the last election. Now, I put it to you, Senator Hinch, I hope this is your last term because we won't be doing it again.
Address your comments.
We won't be doing it again because of the fundamental breach of faith that you have undertaken by this action.
Senator Carr,
and the actions that you have taken.
Comments to the chair.
Thank you, Mr. Deputy. The actions you have taken to aid and abet the conservative forces in this country break the union movement in this country. Now, Senator Hinch, you enter into a political dialogue on the basis of integrity.
Senator Carr, just resume your seat for a moment. The reason we ask senators to address their remarks to the chair is so that the debating points are not personalised. If you want to complain about Senator Hinch's actions, you can do so to me.
And I have. To you. I have complained bitterly about the fact that Senator Hinch has broken commitments he has made in industrial relations questions, particularly in regard to the ABCC bill. Commitments that were undertaken and accepted in good faith, which are clearly now not being honoured. Now, the consequence of that, of course, is for workers and directly in regard to this matter, that we see now that the provision of simple matters like the purchase of Australian clothing, worked clothing, not allowed. Provisions to protect Australian workers in terms of redundancy, not allowed. Arrangements to actually ensure the employment of apprentices, not allowed. And we've not heard any response to these charges. No response to these charges. Now, the Code of Tendering Performance of the Building Work 2016 prohibits the inclusion of construction work for Commonwealth projects that are required to, and as I've indicated in the matters in regard to the apprentices, the hiring of overseas workers, mandating use of Australian-made clothing and the mandating of asbestos training. Is that a fact or not? No one has been able to deny that that is in fact the position. Now, under the Act that was passed last year, against the Labor Party's advice, it became, of course, compliant that those contract arrangements extend through to November 2018. This bill seeks to amend those arrangements. And so for 3,300 companies, enterprise agreements will have to be renegotiated to accommodate those changes as a result of this particular measure. And that will mean, as a consequence of those changes, companies with agreements that have been approved by Fair Work Australia but are not code compliant, they'll be forced to make grossly unfair commercial choices. Either they'll have to decide not to tender for Commonwealth building work, or they'll have to renegotiate the agreements by August, or according to, as I say, in terms of the illegal arrangements, they may well face a situation where they have the best value for money for any contract arrangement, but will be excluded from tendering for any of those Commonwealth work. This is draconian. This is grossly unfair, and it demonstrates the hypocrisy of the arrangements entered into. Because you see, this government that says we want to deregulate, we want people to have freedom of choice. If they choose the union, they choose to organise together, they will be regulated in such a way as they can't organise for their own protection. Now, it would seem to me this is not just something that applies to the building industry. What's happening here, and we've seen it already emerging in the power industry, we're seeing it with the ETU in South Australia, and we're seeing it in a number of other areas. This, of course, is a process that will go through all of industry. This is, of course, the approach that this government takes. If they can get away with it in smashing the CFMEU's capacity to organise it will flow through to other areas. And we're seeing this in terms of the change in industrial relations practice that are taking place, as I say, not just on building sites. This is an establishment of an aggressive, damaging industrial environment that this government is keen to foster, which will undermine not just blue-collar workers. Now, my direct experience in terms of, this is not just conversations that occur in lifts or at post offices. What, of course, we're seeing is the approach, for instance, in science and in research. Now, we've got 1 in 5 of our science jobs in public agencies have been lost since this government came to power. 1 in 5. And it's not just a question of reducing resources for these agencies, it's about changing the industrial environment. The Education Department data shows that as many as 90% of our research academics across our university system are on limited term or casual agreements. There's a report in The Australian today that says that the employer body, the Australian Higher Education Industrial Association, is seeking to strip back enterprise agreements in the name of simplicity. It's the same rhetoric that's being used, although they haven't yet come to the point where they're trying to accuse academics of various heinous breaches of the law. I've no doubt, if necessary, claims of that type will be made. Under the so-called cover of efficiency, scholarly values are at risk, which of course have been in practice for centuries. They've underwritten public confidence in academic expertise and scientific integrity. If we take a very specific example, it's accepted in practice in industrial relations in this country that an expiring enterprise bargaining agreement should continue until a new one is in place. In December last year, the University in Western Australia repudiated that convention. Now, while I don't normally discuss the individual industrial relations of specific universities, Murdoch University, which had been negotiating the terms of a new agreement with the National Tertiary Education Union, applied to Fair Work Australia to terminate the existing agreement. The university also taking legal action against the union and 2 of its officials in Western Australia for alleged misrepresentation. Misrepresentation for arguing their case. In any workplace, such tactics would be regarded as hostile and aggressive. In the higher education sector, they're unprecedented. There is very broad support in this country for the public university system. People are proud of our universities, our institutions that foster a civilised discourse and a diversity of opinion and open inquiry. And they recognise that as a good thing that such institutions are publicly funded. But there would be much less support, I am sure, for the notion that universities should behave as Murdoch University has done in this particular dispute. Australians do not expect universities to act like ruthless private corporations or building developers, which is now happening. And I don't believe it's chiefly because of the particular set of university administrators that have suddenly become more belligerent. What's happening at Murdoch has to be understood in the context of what's occurring in Australian industrial relations, and in particular in regard to the debate in higher education. The Australian budget proposals to deregulate the university fees and increase the proportion of students contributing were essentially a shift towards the privatisation of the university system, a shift towards a system in such short-term commercial gain which would increasingly determine a university's priority. A shift, which I might add, has stalled in this Senate and twice rejected, of course, the government's proposals in that regard. We'll wait and see how people stand up to any pressure in that regard. But the plan still remains on the table, with the Abbott Turnbull version of an Americanised, privatised and corporatised university system remaining government policy. And that's what's happening in Murdoch, is something that really disturbs me as a standard of the enterprise bargaining process. Although the government has had no part in the negotiations, it is why the government must bear, however, some responsibility, and I'd say considerable responsibility, for shaping the industrial relations environment. Terminating the enterprise agreement would mean reverting to a basic award coverage. And we see that in the building industry, where basic award coverage would see substantial reductions for building workers. The university, in this case, however, would be able to decide which, if any, of the existing above award conditions and entitlements of employment were maintained, as they would in the building industry. And not only that would be seen because of the reduced material entitlements under award conditions. Now, the consequence of that is, of course, bad enough. What we'd see is pay cuts for academic staff between 25% and 40%. For professional staff, pay would be cut by 39%. Employer-provided paternal leave would be eliminated. Misconduct and unsatisfactory performance processes would be removed. And even worse, we would see profound consequences for the nature of academic work and for the standing of the university. Namely, the protection of academic freedom would be eliminated. Provision for the regulation of academic workload would be eliminated. And the Murdoch University Strategic Plan for 2012-17 sets out a list of values that it says, and I quote, "An intrinsic part of the university culture, these values must give a sense of identity and continuing context for all its activities." Now, the values that they talk about are scholarly integrity, equity and social justice, sustainability, and global responsibility. But what's occurring at the university there is actions which are fundamentally undermining those assumptions, a course of action which imperils the university's own declared values. Abandoning formal protection for academic freedom is just incompatible with a commitment to scholarly integrity. A university, by definition, is an institution that facilitates the free exchange of arguments and ideas among scholars and between scholars and the wider community. Some might say surely the Murdoch University would not risk its reputation by obstructing the free exchange of ideas. But sadly, what's happening is the university administrations have already shown they're willing to countenance restrictions on freedoms. Negotiations that have been proposed to define of misconduct would include any breach of policy or regulation, any action by an employee deemed to pose an imminent risk to the reputation, viability and profitability of the university. I emphasise the profitability of the university would be classed as serious misconduct, punishable by dismissal. Now, it takes no particular special insight to understand that these are existential threats that would pose to all of academic freedom in this country should such a process be established. So what's happening in terms of enterprise bargaining at a university, of course, can see parallels with what's happening in the building industry. And it's indicative of a government that's hostile to the interests of working Australians across the entire economy. If the government does not abandon its goal by trying to privatise by stealth our public institutions, then we will see, of course, this whole process being extended throughout other government agencies. And the government doesn't abandon its attack on unions and workers, as we see in the construction industry, it will see, of course, that working people across all industry have cause for real concern about the consequences for them if the government is successful in smashing the CFMEU and smashing the capacity of building workers to defend themselves against the actions of employers who have, of course, shown for time and time again their capacity for mendacity, their capacity to exploit workers, their capacity to treat workers in a manner which is just downright dangerous, their capacity to do anything to secure the contract, to secure their profits. These are what the questions at stake here, not whether or not someone stops you in a lift and says, "Oh, look, sorry, I think you've done the wrong thing, Senator." Not someone that, of course, who was already hostile to the capacity of working people to defend themselves, not someone, of course, that has an interest in undermining fundamental principles of industrial relations in this country, an attempt to criminalise normal industrial action who in the pursuit of increasing people's living standards and defending their rights at work.